Hi, I'm Darcel Lobo. I own DAL Law Firm in Normandy Park, and today we're going to answer, I think, the number one question that I get when I am meeting with estate planning consults. And what is that question? The question is, do I want a will or do I want a trust? For a lot of clients, they are unsure. They've heard a lot of things, whether it's from Google, from videos, from friends or family, and they're not sure what's right for them. Well, today we are going to kind of go through the pros and cons, explain the difference of both, so you can be better informed as to which option is right for you. Now, as a quick disclaimer, I am in kind of the greater Seattle area, and I am only licensed in Washington State. So as much as I would like to help people across the country, I am only licensed in Washington. So if you are outside of Washington, I'm very sorry. I cannot assist with your estate plan, but I would suggest contacting your county or state bar association to get a referral. So, okay, now that that's out of the way, let's just dive right into a will versus trust. So let's start with a will. A will is a set of instructions of what you want to have happen, but it does not empower anyone to do anything without probate, okay? So the will is a set of instructions of what you want to have happen. Upon your passing, that will gets filed with the probate court. Probate is opened and a judge oversees the administration of your estate pursuant to the terms of your will. So in your will, you're going to say who gets what, you're going to say who your executor is, you're going to have everything outlined, but it has to go through probate in order for that to actually happen. Now, there are a few caveats to that where you can avoid probate with a will. You may have heard of a small estate affidavit. I will link another video about that below. A small estate affidavit is only for estates that have no real estate and the value of the probate assets that would go through probate are under $100,000. So if you have real estate or the value of your estate that would be subject to probate is over $100,000, the small estate affidavit would not work and your estate would go through probate if you have a will. Or if you don't have a will, if you don't have an estate plan, the state of Washington has an estate plan for you. And it may or may not be what you want, but that's what you're going to get. So if you want to decide who serves as your executor and what goes where of your assets, then we need to at least have a will. So again, the will gets filed with the court. The probate court oversees the administration of your estate according to the terms of your will, ensuring that the will is followed. Okay? The other option is a trust. The proper name is a Revocable Living Trust. You create this document during your lifetime and you put your assets into this trust. We do most of that for you when we prepare your trust for you. The trust outlines what happens. Instead of an executor, you're going to have someone who is your successor trustee, and it's going to outline all the distributions as far as who receives what. But the biggest difference between a will and a trust is that the trust does not have to go through probate. There will be no court involvement in your trust if you form the trust and you fund the trust. Okay? And so that is really the biggest difference. So why would you want one or the other? Now, clients have different perspectives on this. A will is less expensive to set up. The trust is more expensive. However, when you factor in the cost of probate on the back end after you've passed, the will option plus the probate is going to cost more than the trust option. But for the initial out-of-pocket for drafting your estate plan, the will option is less expensive than the trust option. So I usually have about 3 reasons why my clients would want a trust over a will. The biggest one is if they have real estate outside of Washington State. So if you have a home here, but you also own real estate, most commonly it's Arizona. So my clients are snowbirds, right? They go to their property in Arizona for the winters. So if you have property in Arizona or Hawaii, California, but anywhere outside of Washington state, you're going to want to go with the trust in that situation, because otherwise you'd have to have probate here in Washington plus any other state where you owned real estate. So having that trust that holds all those assets and all that real estate in the trust, that avoids not just probate, but having to have multiple probates in the various states where you own real estate. That's the biggest one. So if a client has real estate outside of Washington state, I highly advise that we go with the trust option. So what are the other options or other reasons? For a lot of times, most of my clients is personal preference. Some clients, they don't want a court involved in their final affairs. For some clients, it's very important that their family not have to deal with the courts and not go through probate. Now, probate in Washington state is much more streamlined than other states. Like, from what I hear, California is a state where you don't want probate because of the cost and the time. So probate is pretty streamlined, but for some clients, they don't want that for their families or loved ones. They don't want their estate going through probate. And so they don't want a court involved in their affairs. So that's a reason as to why they'd want a trust. For some other clients, privacy is really important to them. And the wills get filed with the probate court. They become public record. So anyone could look up and see not only what the will said, but also the probate as far as who received what, how much did they receive, because there is a declaration of completion at the end of the probate that kind of recites all that information. And so that becomes public record. And for some clients, they don't want that. They don't want public record of what the trust says and who receives what. And so with the trust, it does not get filed with the court. It does not become public record like the will does. Those are kind of the three big reasons why I see why clients would want a trust over a will: the privacy, keeping the court out of your final affairs, and if you have real estate in multiple states outside of Washington state. So, but otherwise, we can achieve the same goal with the will as we can with the trust. If we need to provide for minors, if we need to appoint guardians for minors, whatever distributions you want to do, if we need to do any kind of tax planning for your estate, we can do all of those things with a will and with a trust. So it's not a matter of achieving a certain goal, like a certain end goal, because the end results can be the same with either option. It's how do you want to get there? How do you want the estate to get there? What vehicle are we going to use to administer your estate and distribute everything to your heirs? Are we going to use a will and go through probate? Or are we going to use a trust to avoid probate? Both options are fully revocable. You can amend them. So they both have all the same options within the documents themselves. It's just, how do you want your estate to be administered? That's really the bottom line question if deciding between a will or a trust. Now again, some clients, maybe they have experience with probate, or maybe they had family who had a trust, so they already come to me knowing one way or the other what they do or don't want. And for some clients who are undecided, we have this conversation and discuss, what their estate looks like, what the distributions will look like, who the heirs are, and I go over this with them. Now we do it one-on-one, so I can kind of factor in their estate and what their questions are to decide which option is best for them. And for some clients, it is a financial decision as far as what costs less out of pocket, and I certainly understand that. So I want to design an estate plan that works for you and reflects what your wants and your wishes are for your estate. You've worked really hard, throughout your life to acquire your assets. So we want to make sure that we take care of them and we protect them for you. And if you decide to go with a will for now, and if down the road you decide that you want to do a trust instead, we can do that. Neither of these options are set in stone forever. But we want to have an estate plan that's comprehensive, that we really thought through as far as what's best for you, and for those you've named in your will or your trust. And so we work together to develop a comprehensive estate plan for you. So I hope this helps you if you're deciding between a will and a trust. And again, if you're in Washington State and you need help with your estate plan, give our office a text or a call. We're at 206-408-8158, or you can visit us online at dallawfirm.com, and I'll have all of that linked below for you. All right, have a great day. I'm Darcel Lobo. I own DAL Law Firm in Normandy Park, and today we're talking about deciding between a will and a revocable living trust. Which one do you want? Which one is better? Let's get into it. So we're first going to start off talking about what a will is and what a revocable living trust is. A will is a document that's really a set of instructions. What do you want to have happen upon your passing? It's a set of instructions, but it does not empower anyone to actually do those things. It has to go through probate. Probate is a court process where the court oversees the administration of your estate pursuant to the terms of your will. So the will gets filed with the court along with some initial documents to open probate. The judge will review it and appoint the person that you've named in your will as your personal representative to be in charge of your estate. When the judge signs this order, you're going to get issued what's called letters testamentary. A lot of times clients come into my office saying, the bank says I need letters testamentary. The title or escrow company says I need letters testamentary for the person's estate. So yes, you get this through probate. Once probate has been opened, the judge signs off on it, and the clerk issues letters testamentary that says that you as the executor have the ability to administer the person's estate. So if you're doing a will, it's going to come with probate later down the road. There are some small exceptions here in Washington State. I'm in Washington State, the greater kind of Seattle area. And so with the will option, there will be a probate again, except for those few exceptions. One of them being if you had no real estate and the value of your estate's under $100,000, you should not need a probate. You should be able to use a small estate affidavit. However, otherwise you're looking at probate for your estate. The other option, the Revocable Living Trust, is a living document that you create now. You create this trust now. You are the trustor and the trustee of your trust. You would handle your own assets just as you have beforehand. There's no tax ID number for the trust until after you pass. It all goes through your social. There's no special tax reporting required. But what the trust allows is that you are your own trustee, so you can do whatever you want with your assets, but then you name someone as your successor trustee. Upon your passing, your successor trustee is enabled through the trust to administer your estate according to the terms of your trust. So in your will or in your trust, you're laying out what's going to happen, who's going to receive what. But with the trust, it does not have to go through probate. There's no letters testamentary, okay? The person that you've named as your successor trustee is authorized and enabled to just make the distribution. So liquidate assets, pay any debts that you had, and then make distributions to whoever you have named in your trust. So why would you pick a will? Why would you pick a trust? The will is less expensive to set up. The trust is more expensive, and I have a video, I'll link it below, that explains kind of currently what the prices are for those options here at my office. Again, depending on the complexity of your estate, it could be more. If it's simple, it's going to be, on the lower end of the range, but I do provide that pricing. Also, we do post it on our website, which I'll also make sure is linked below, so you have that information about our pricing. So the will is less expensive to create. The trust is more expensive to create. However, with the will, you're going to have the back end cost of probate. The cost of the will plus the cost of probate in total exceed the cost of the trust. Okay, so at the end of it, the cost of the will and probate are more expensive. However, initially to set up the will is less than the trust. So those are some factors to consider. So let's talk about when clients come to me, some of them have already decided, I know I want a will, I know I want a trust. They may have experiences, maybe someone else in their family or a friend have passed away and they have experience with one or the other, and so they already know when they come to me what they want. If you don't know what you want, I usually give clients a few explanations as to why people would pick a trust over a will or vice versa. So we're going to go through those. So the first one, as I mentioned with the will, is going to go through probate. For some of my clients, they don't want a probate court involved. They don't want a judge involved in their final affairs. So that for them is important enough that they want to do the trust instead. Along those same lines, the will and the probate is all public record. Anyone could go, nowadays, depending on what county you're in, but here in Washington and in King County, it's all available online for anyone to see. So they're going to see what your will said, who received what, and in the probate, it's going to give an accounting of what the assets were, what the debts were, what was left, and what got distributed. For some clients, it's very important that that not be public record. They don't like that being public. They like the trust that gives them privacy because the trust is not filed with the court. It does not go through probate. It is not public record, and they want that for their estate. The third reason is that if my client has real estate in Washington state as well as a different state, I am highly recommending that they do a trust, or else you're looking at probate in each of those states. It's not uncommon for my clients to have a second property, maybe in Arizona or Hawaii or California. And so, maybe they're snowbirds, they go down there for the winters and come back here for the summers. And so if you have second or additional properties outside of Washington state, I'm going to highly recommend that you have the trust, or else you're looking at probate in each of those states where you have those additional properties. And most clients don't want that. Whether you do a will or a revocable living trust, both can be amended or changed or revoked at any point in time in the future. So we're creating this plan now because we want you to have a plan for your estate. But if things change, and they do sometimes, 5 years down the road, 10 years down the road, these are not set in stone forever. You can always come back and make an amendment to it, make some changes later, as long as you have the competency to do so. And so those are kind of some of the reasons why someone would choose a will versus a trust, what the differences are, and a short explanation of how those two different documents work. So if you need help with your estate plan, to create a new estate plan, if you want to talk about a will for yourself or a revocable living trust, give our office a call. We'd be happy to help. Our number is 206-408-8158, or you can visit us online at dallawfirm.com. Thank you. Hi, I'm Darcel Lovo and I own DAL Law Firm, and today we're going to talk about the estate planning process when working with our firm to help you with your estate plan, whether it's a will or a trust or a number of different options that we have available here to you in Washington state. We're going to kind of go over what that process looks like and kind of demystify it, because I think for a lot of people, the hesitancy in reaching out to get an estate plan done is that it seems a little overwhelming, it seems too complex, it seems very complicated and burdensome and expensive, right? And all these things that lead people to not get their estate plan done when they really should. I meet with a lot of people who say, I wanted to do this 5 years ago, 10 years ago, or a lot of times maybe even longer, right? I mean, for a lot of my clients, it's their first time getting a will done or a trust done, and they have kids that are grown, they have grandchildren. So I wanted to break this down because I was very intentional with how I structured my law firm. And when it comes to estate planning, I want to make it as easy as possible. I want to kind of demystify that process and those documents and make it not so scary, right? So let's talk about step one. The first step is having a consultation. Now at my office, I currently do them by phone, by Zoom, and in person. I'm located in Normandy Park, which is like the South King County area. But if that's not convenient for you, again, phone or Zoom is an option as well. To really talk about what does your estate include, what is your intended distribution, talking about your home, if we're leaving things to children or grandchildren or other friends or family or maybe charities, kind of what do you want for your estate? And for some clients, a simple will is all they need. For some clients, we have to prepare or provide for minor children and their distributions and guardians for them. For some clients, they want a revocable living trust to have their estate avoid probate. So we talk about everything, and I answer all the questions that you have. Now, when you contact our office for a consultation, once you schedule, we're going to send you a confirmation email that has an estate planning guide that kind of goes over the process, what to expect. It explains all the documents that come with your estate planning package. So really just breaking things down for you. And then you'll also get an intake form for you to fill out that gives us your full name. If you have a spouse, your spouse's full name. If you have children, their full names. Whoever you want to provide for in your estate plan to be your power of attorney. If there's anyone that you don't want to provide for, we want to know that as well. We really kind of just talk about these things in simple, plain, easy to understand terms because I want my clients to understand what their estate plan says. I can't tell you how many times I've had somebody come to me for a consultation. They had a will or a trust done somewhere else. They bring me this big stack of documents that they haven't even looked at since they were signed, and they have no idea what it even says or what it means. I want to take that away. Now, because they're legal documents, there are legal terms that I have to have in them, right? In order for them to be valid documents. But I want you to understand them. I want you to know what it says. That's very important to me. So at the consultation, we discuss what you want. I give you a flat fee for the estate plan. There's no surprise bill at the end. You know exactly when you hire me what the cost is going to be. We do them on a flat fee basis. So that's step one. And a lot of times that's the hardest step, is just the initial outreach to have a consultation. So if you want to do so with our office, we're only licensed in Washington State. So I cannot help individuals outside of Washington State. I'm sorry, I wish I could. But if you're in Washington State, you can text us at 206-408-8158. You can call us. I will have our website down below. You can email us. So there's so many ways to contact us for us to be able to help you with your estate plan. So that's step one. Step two is after we've had the consultation and you have decided that yes, you want to proceed with your estate plan, we've discussed what that's going to be and what the cost will be, then I get to work. Me and my team, we get to work drafting your documents for you. So currently, and it's May 2024 right now, my current turnaround time is about 2 to 3 weeks to have your drafts ready for you to review. Some clients like to review them in hard copy, so I'm happy to mail the drafts to you. Some clients, if they're close by, they'll come to the office and pick up their drafts. Or for some clients, we have a secure online portal. I don't email them to you, that's not secure, but we have a secure online portal for you to use that I can upload your drafts to, and you can log in there and review them there. Whatever is easier for you to review your documents, that's what we'll do for you. So you'll review them, and now we're in step 3 already, which step 3 is you reviewing the documents, letting me know if you want any changes, any edits, and then once you've approved them, you let me know, hey, Darcel, these are good to go, we're ready to sign. Then we're to step 4. Step 4, we schedule signing. We do it at our office, generally speaking, because we need notary and we need another witness, and so I provide that at my office for you, so you don't have to bring any witnesses with you. You don't have to worry about notary. I provide that for you. So you'll come to our office. We'll meet in my conference room. We'll review the documents. We will sign them all. We'll witness them. We'll notarize them. And once that is done, your estate plan is in full force and effect. It is valid as soon as that pen hits the paper. So you will not receive your documents at that time, but they are in effect. Our office keeps them because I scan them into my system, so I have records of what was signed and what was done. And then I put together an estate planning binder for you that has all of your original documents. If you want any copies, I'm happy to make copies for you, along with instructions and information for your family and loved ones to know what to do in the event of your passing. And so I have a video, I'll share it below as far as what's in your estate planning binder, but we prepare this binder for you. And when you're done, you have a full complete estate planning binder with all of your documents, resources for your family and loved ones. everything that you need. Usually I need about a week for that to be ready. If we're doing a revocable living trust for you and I have to record your updated deed with the county, it can take a little bit longer, maybe more like 10 to 14 days, because we wait until that deed has been recorded with the county so we can include that in your binder. But we handle that recording for you. Again, we try to make this as easy as possible for you. And I will say that I've had a number of clients tell me, like, this is a lot easier than I thought it would be, and they're appreciative of the ease of it. It's a difficult conversation to discuss what you want to have happen, upon your passing or upon your loss of capacity, and to think about these things. But I tell my clients, having a thorough and comprehensive estate plan, again, doesn't have to be complex, okay? It can be something simple, but having that in place is one of the best gifts you can leave to your family. Because I work with so many families where there isn't a plan in place. They don't know about the person's assets or where they banked or what bills they had. And so for you to put all this together, and we do most of the work for you, right? We put this binder together for you. It's just such a great gift to leave to your family and your loved ones. And also the peace of mind for you to know that this is complete. Usually it's a big item on my client's to-do list is to get this done. So we're here to help you to get this done. So again, I'm Darcel Lobo. I own DAL Law Firm. I'm in Normandy Park. If you need help with your estate plan, give us a text or a call. Our number is 206-408-8158. Or you can visit us online at dallawfirm.com, which I'll have linked down below. Thank you. As an estate planning attorney, I'm in Seattle. One of the first questions that we usually get at my office is, how much does the estate planning cost? How much is it going to cost me? And I understand. I think for a lot of people, the notion of getting their estate planning done immediately just brings about thoughts of dollar signs. Lots and lots of dollar signs. So I have to say, the cost of estate planning is going to depend. And I know that's a very lawyerly answer to give, but that's because not all of my clients' needs are the same. I've been helping clients with their estate planning needs for 14 years now in the greater Seattle area, and I'm Darcel Lobo, by the way. I own DAL Law Firm, and so what I strive to do with my fee structure, whether it's estate planning, our real estate practice, any of our practice areas, I really strive to be transparent with my fees. And so this is why I share most of the fees in my firm on my website. I post them there so that when you are looking at my website, reading the information I have on the website, I have a lot of resources, a lot of videos there. You can know also kind of what to expect. Now, a lot of my pricing is going to be the price starts at this amount, or I might provide a range between this and this, because again, each case will be unique. I might have, a married couple with a very simple estate plan. Maybe they have, 2 children, 1 house, the personal belongings, maybe, a few financial accounts. And maybe I have another married couple that owns a few businesses. Maybe they have an investment property. Maybe they have minor children we have to provide for. I need to know more about the facts of your case before I can give you an exact price. But when we have our consultation, I'm able to get enough information that I can tell you, okay, this is what your price will be. So on my website, which is dallawfirm.com, dallawfirm.com, and I'll also link it down below for you. I'll link the exact page where I have all my pricing. I actually pulled it up so I had it in front of me while I was talking to you today. So like for a simple estate plan for an individual person, that starts at $795. But that includes more than just your will. If we're going to do your estate planning, let's get it done correctly. We need to do your financial power of attorney, your healthcare power of attorney, your directives. Let's just get all of that done so you don't have this hanging over your head later. It's more than just the will. Even for a simple estate, because these documents serve different purposes. And if you're going to come to my office and hire me and meet with me and go through all the steps to get your will done, we should just do it right and do your power of attorneys and make sure you have a comprehensive plan in place. So I have those fees on my website. Again, an individual will package, $7.95 is the starting price. For a married couple, will package, which includes a community property agreement, if that applies to your case, which we'll discuss during the consultation, that is $13.95. If you are looking for a revocable living trust for an individual, that starts at $2,500. For a married couple, that starts at $3,000, but that includes one piece of real property. If you have multiple real properties and you want to have a revocable living trust, which, by the way, I will link the videos I have about why you might want a trust versus a will and the differences, I will list that below. But if you have a trust, for each piece of real estate that you own, we have to prepare a deed for each property to put that deed, that property, into your trust. So we have more work to do, which is why the trust is more expensive if you have more properties. Or maybe you are fortunate enough that we need to do tax planning. Your assets are at the value to where we should start talking about tax planning and integrating that into your estate plan, which is going to cost more money. But I'm going to tell you the amount you're going to save on the estate taxes, which in Washington State, as of the time of this video, which is June of 2023, the exemption amount for an individual in Washington State is $2.193 million. So if your estate as an individual is under that threshold, taxes, estate taxes at least, are not an issue for you. But if you are over that amount, and for a married couple, we can do planning to double that for you to about $4.386 million that we can exempt, meaning we can protect it from estate taxes, at least at the state level. At the federal level, the threshold is much, much higher. So we're not concerned about that if we're looking at $2 million or $4 million. If you are over that or you're approaching that, we're going to talk about tax planning and what we can do to provide tax planning services for you, for your estate, because the amount of taxes you're looking at potentially, again, in Washington State, as of the time that I'm making this video, is between 10 and 20% of your estate that's over that exemption amount. That could be a pretty large tax bill. So when we're looking at the cost of estate planning and doing some tax planning, we have to factor in, what is the benefit? What is the value to your estate? What is the value to your children? What is the value to your legacy and what you're leaving behind? So that's where the pricing of estate planning can become more complex, can become maybe higher than what I have listed as my starting price on the website, but at least it gives you an idea of what numbers you're looking at. And for sometimes, you know, what I found with a lot of law firms is that they don't want to give you a price, and it can be hard to give a price, and I understand that, but I at least want to provide you what the pricing starts at, what the range might be, so you can at least know that when you're reaching out to my firm, kind of what you might be looking at, and so it won't be sticker shock. And also because for some clients, if you are looking for the cheapest option, the cheapest option for your estate plan, which I would highly advise that you maybe reconsider, but that's not going to be my office. I can tell you, right now that I'm not going to be the cheapest estate planning attorney. I'm also not the most expensive. You can go to downtown Seattle and spend double or triple what my fees are. So I think my fees are very reasonable. They come with the past 14 years of doing this work for clients who are just like you. And so for clients who come to my office and want to work with me, they know going into it kind of what they're looking at, what to expect, and it won't be as much of a surprise to them. And then also talking about pricing, if you are considering a do-it-yourself plan, maybe a template online, a form somewhere, you certainly can do so. A lot of those documents are valid in and of themselves, but if you don't complete them correctly, if you don't have someone to help guide you and advise you as to why a plan may or may not be the best option for you, if you don't have someone explaining to you what a transfer on death deed is, which is specific to Washington State, and a lot of these national templates aren't going to provide for that or not going to explain that to you, then you don't know what all your options are. You don't know what all the opportunity is for your estate planning. And estate planning doesn't have to be complex. It doesn't have to be hard. It's really going to depend on what your circumstances are and what you want for the distribution of your assets. And so I'm also going to share a video below that I made before about kind of do-it-yourself estate planning, because it certainly can be done. So I want to make sure that if you do so, that you do so from a place of being informed about that decision. So knowing what the pricing might look like before you even pick up the phone to call our office, before you even email us to make an appointment, you can already know what pricing looks like. And besides posting it on my website, when you contact my office and you make an appointment with my office, we're going to send you a confirmation email for your appointment. And in that confirmation email, I prepared a guide that walks you through the various options, what the packages include, what that pricing looks like, explaining what these documents are. What is a power of attorney? When does it work? How do I use that? How's that different than a will? How's a will different than a trust? We include all this information for you before you've even spoken with me for your consultation. So you come to that consultation with me being so much more informed than you probably were beforehand. So we can have this conversation about what is best for you. What do you want your estate plan to look like? That's what's most important for me, is that I create a plan that reflects your wishes and your intentions, because you worked very hard to acquire your assets and to build your wealth and to, whatever you have acquired through, your working, your investing. I want to make sure we have a plan that works for you and it's going to benefit you and your family. And so that's what we discussed during the consultation. And so with the consultation, with my estate planning, we're doing more than just your will. We're doing more than just your trust. We're evaluating those options. We're going over power of attorneys. We're going over directives. We're making sure that you have a comprehensive plan, because having an estate plan is one of the best gifts you can leave to your family. Regardless of what the assets are, if there's no plan in place, if you haven't outlined what's going to happen and who receives what, and you end up leaving that to the state of Washington to decide. You end up leaving that to a judge who knows nothing about your family dynamics, knows nothing about the relationships in the family and what you may have wanted, what you may have told somebody one time. Let's have a plan in place so you can provide your family with that peace, a well thought out plan that is considerate of all the various factors to consider in your family dynamic and situation, so that all they have to do is follow your instructions instead of trying to make these decisions and figure out what happens, what would, mom and dad or grandma or grandpa or my sister or my brother, what would they have wanted? Let's just have a plan in place for them and take that off of their plate so they don't have to worry about that. So I think it's really important that you have transparent pricing, whatever attorney you use, whoever you hire, whether it's my office, someone else, if you're in Washington State or anywhere else in this country. You want to make sure that you understand what it is you're purchasing from that attorney, what service they're providing to you, what value you're receiving from that estate planning service. So if you need help with your estate planning needs and you're in Washington State, again, I'm only licensed in Washington State, feel free to give my office a call. The number is 206-408-8158. I will make sure to also list our website below where you can reach out and contact me directly, and I'd be happy to work with you and get an estate plan in place for you. All right, thank you so much and have a great day. Hi, I'm Darcel Lobo. I own DAL Law Firm in Normandy Park, and today we're talking about if you can avoid probate in Washington State. And the short answer is yes. If that was the question and you wanted a yes or no answer, the answer is yes. If you want some more details about how and why and what to do, then let's get into that. So let's start off with what is probate. Probate is a process whereby a court oversees the administration of someone's estate, whether they have, a will, or if they don't have an estate plan at all, no will, no trust, no anything. The court's going to oversee to ensure that the estate is distributed according to the terms of what state law says, or if there is a will, then according to the terms of what the will says. And there's confusion with this sometimes. Sometimes people think, well, I have a will, so I won't need probate. That's not correct. Okay. A will is a set of instructions of what you want to have happen to your estate after you've passed away. But in order for it to happen, it needs to be admitted to probate. Probate needs to be opened for the court to oversee the distribution of all of your assets, the payments of your debts, and distributions to heirs according to the terms of your will. But there are some ways around this. Okay, so let's get into what those are. And I will say that probate can be different state by state across the U.S. So here in Washington State, probate is more streamlined, more efficient, and not as expensive as in other states. I know I've heard notoriously that California is a state where people do not want probate. Given the time and the cost, I believe the cost is like a percentage of the estate. We don't do that in Washington. So if you've heard that before, if you've seen that online, you've Googled that, or if you know someone who may be from California or had experience with probate in California, you may be hearing that, but that's not how it's done in Washington. Okay, so let's talk about some ways that you can avoid probate in Washington if you do want to avoid probate. A revocable living trust. That is usually the key way how a lot of my clients elect to avoid probate. You create the trust now, you put your assets into the trust now, you are the trustee of your own trust during your lifetime, so you can control your assets just as you do now. But upon your passing, you've named someone as your successor trustee who steps in, takes over the assets, and distributes them according to the terms of your trust. So the trust says everything gets split, between my son and my daughter, 50-50. The trustee will do that, not have to go through probate, not have probate court involved in that. They're able to just do so outright as your successor trustee. In order for the trust to work, it has to actually own the assets. So when we create your trust for you, we will fund, it's called funding your trust. We will fund your trust with your real estate that you own, put your personal property into your trust with your personal property assignment, talk to you about naming the trust as beneficiary or account holder of financial accounts and various financial, investments, things like that. So we'll talk about all that when we do your estate planning. So a revocable living trust is kind of the biggest way that, what we use to help clients who want to get their estate plan in place and want to avoid probate. Another way is that if you own property joint with right of survivorship, that means that that property will pass automatically to the other co-owner. So let's say you own a home. And I talked about this recently in another video, so I'll try to make sure it's linked down below for you, if I remember. If not, it's in the recent history talking about joint ownership. But with joint ownership with right of survivorship, that means, let's say that you bought a home with someone else. Let's say you and a friend bought a home together. You bought it 50-50. If you own that home, and if the deed says that you own it jointly with right of survivorship, that means upon you passing, your 50% interest would go to the survivor of you automatically, and vice versa. If they passed away, their 50% would go to you if you own the property joint with right of survivorship. Okay, so that's another way to avoid probate, is for that asset to pass to that survivor of you. And if you could have 3 people on title, you could have 4 people on title, it doesn't matter. but it would pass automatically if the deed is set up joint with right of survivorship. You can also do this for a lot of your financial accounts, like a checking account or a savings account. You can add someone onto your account to be a joint account holder with right of survivorship. So upon you passing, that asset, that account would go to the survivor of you automatically, and it would avoid probate. Another way for real estate here in Washington state specifically, other states have this option as well, but I'm just focused on Washington because I'm only licensed to practice in Washington, is a transfer on death deed. So a transfer on death deed is where you name a beneficiary to real estate. So let's say you own a home and you want that property to go to your adult child, and it's just one adult child. We can prepare a transfer on death deed where we name that adult child as the beneficiary of that property. And so that upon your passing, that real estate can transfer to them without having to go through probate. That transfer on death deed is fully revocable, so if you want to change it during your lifetime, you can do so. Upon your passing, it goes to the person that you've named. Along those same lines is beneficiary designations. So for all of your financial accounts, you should be able to name someone as a beneficiary. And so if you do so upon your passing, that account will go to whoever you have named as beneficiary. Here's the one thing about beneficiary that I will say about this, is that you may have opened an account 20, 30 years ago, especially if it's a retirement plan through work or a life insurance policy, and you name someone as beneficiary, but you haven't looked at that or reevaluated that since you set it up. And the person that you named 20 or 30 years ago may not be the same person now that you want to receive that asset. So you have to please ensure that you are updating your beneficiaries as there's life events, if there's births, there's deaths, there's marriages, there's divorces. Please ensure that you are updating those beneficiary designations. And a lot of institutions will allow you to name more than one person. So if you have 2 kids or 3 kids and you want to name both of them equally or the 3 of them equally, you should be able to do so. Talk to the institution about what limitations they may have on the beneficiary designations, or sometimes you can do someone as primary beneficiary and somebody else as secondary beneficiary. So make sure you understand what options are available to you and that you are updating those beneficiary designations as, life happens, life changes, and you want to change who receives it. Make sure that those are updated as well. Please do not name a minor as your beneficiary. If there's any takeaway from this, please let it be this. Do not name a minor as a beneficiary of anything, okay? Under Washington state law, they are not competent to inherit something. So there's going to be a whole lot of court involvement, most likely, if you've named a minor. So please do not do that. All right, enough about beneficiaries. Next option. If somebody has already passed away and they have what Washington state determines is a small estate, that is an actual term, a legal term that we use. If they had a will or they didn't have a will, if their estate qualifies as a small estate, you should, if I could make a little asterisk sign, I would do that right now. You should be able to use the small estate affidavit to collect those assets. So to qualify for a small estate, there cannot be any real estate as part of the estate, and the value of assets has to be under $100,000. If you meet those 2 criteria, you should, again with an asterisk, be able to collect those assets if you are the rightful heir to those assets with the small estate affidavit. Now, why am I saying should? Why do I have this caveat with that? Because this process is Washington state specific. And a lot of these bigger banks are national banks and are not as familiar, or they pretend to not be as familiar, I'm not sure which it is, with the small estate affidavit. So I have unfortunately had many clients where the estate qualified as a small estate affidavit, as a small estate, and should have been able to use the small estate affidavit, but the bank will not process it. The bank says, no, we need letters testamentary. And you can go back and forth and back and forth and back and forth with them, and they still come back and say they need letters testamentary. So sometimes I can get involved, write a letter explaining what the law is, why the bank is wrong, why they need to release the funds, cite the statute in Washington State for small estates, and hopefully get it released. The amount of time and the back and forth and all the delays, for a lot of clients, it's just more efficient to just open the probate, to just have me open the probate, which is unfortunate because they don't have to. They shouldn't have to. But the bank isn't releasing the funds without letters testamentary. So the small estate affidavit process is an option if the estate is a small estate. However, just know that you may encounter, especially with your bigger banks, your national banks, your Bank Americas, your U.S. banks, like, I'm going to call them out. I have experienced firsthand where they will not process these, and they will refuse to do so, and they demand letters testamentary even though they are wrong. So those are kind of the options. So let's see, we went over trust, we went over joint ownership with right of survivorship, we went over transfer on death deeds, we went over beneficiary designations, we went over a small estate affidavit. So those are kind of the main ways in which you can avoid probate here in Washington State. Again, probate in Washington State is really not as bad as you may have heard as in other states. But for some clients, they don't want their family or loved ones or friends to go through probate. And aside from going through probate, which is a court process, they also don't like the idea that probate is public record. So your will, the probate, what your assets were, what your debts were, how much your heirs received, that all is public record, and sometimes clients just don't like that. They want more privacy. And so those are the options to avoid probate, kind of how you would do so, when you would use these different options. So if you need help with your estate planning, we'd be happy to help you. Again, I'm the owner of DAL Law Firm. I am Darcel Lobo. I am an attorney. Feel free to reach out and give us a call or text at 206-408-8158, or you can visit us online at dallawfirm.com, and I'll have all that below for you. And if I remember, I will also link the videos that I've referenced during this video for you to check out also if you want to do so. So, all right, I hope this helps, and I'll see you in the next one. All right, bye. Hi, I'm Darcel Lobo. I own DAL Law Firm in Normandy Park. I'm an attorney, and today we're going to talk about estate planning and how to simplify estate planning if you own real estate in multiple states. So I'm in Washington State. I'm only licensed to help clients who are Washington State residents. But for many of my clients, aside from having real estate here in Washington, they may also have a second home, an investment property, or a vacation home, or maybe they have like a, just other property in different states for whatever the reason may be. And, we want to put together a comprehensive estate plan that covers that out-of-state property and really kind of simplifies things for their families. And so whenever I have a client who owns real estate in multiple states, I'm always recommending a Revocable Living Trust for their estate plan. And so why is that? Well, that's because if you own real estate in different states and you have a will, you're likely looking at a probate in every state where you own real estate. So you'd have your probate here in Washington, and then wherever else you have real estate, there's probably going to be a probate there as well. Unless you have like a transfer on death deed or a beneficiary deed for that property in that state, you're looking at multiple probates. And so it's pretty, for a lot of my clients who have real estate outside of Washington State, a lot of them have second homes in Arizona, Hawaii, New Mexico is a big one. There's a few states where I just kind of have a number of clients who have second, homes in those states. And so I recommend to them doing a revocable living trust, because even though that property is outside of Washington state, we can form their trust here in Washington, put their Washington real estate into that trust, and then we can also get that property in that other state deeded into their Washington revocable living trust. And that way, the Revocable Living Trust includes all of their assets, both inside and outside of Washington state, avoiding the need for probate at all. And so it really kind of simplifies and streamlines the process, saves on cost of having multiple probates in those different states. Or sometimes I'll have clients who maybe they don't own real estate outside of Washington yet, but that is their plan in the future. And if they're trying to decide between a will or a trust, that could be a factor to consider as far as going with the trust, is that if you plan to have real estate outside of Washington in your future, well, then maybe we should just do the trust, now, so you're not having to do it down the road. But keep in mind, if you do a will now, you can always do a revocable living trust later, as long as you have the competency to be able to do so. You can do so later, so you're not, barred from doing so. The will that you make now is not set in stone forever. You can update it or change it as you need to. And if you have a will now and doing a trust down the road makes more sense, then you can do that later. That's fine. But for clients who are just trying to put together their plan now and don't, really want to know that even though we've done this now, they're probably looking at redoing it later as a trust, then maybe we just do the trust now. And so that's a big reason why we look at revocable living trusts for clients if they have real estate both in Washington state, but also outside of Washington state. Now, there's other reasons as well why clients may want a revocable living trust, even if they don't have real estate outside of Washington state. For some of my clients, privacy is really important to them. And with the will option, probate is open, the will gets filed, the will becomes public record. So anyone, when someone's passed away and the will's been filed, anyone can search the court records by their name, the decedent's name, and see what the will said and see who received what, and in the probate, so anyone could see how much the assets were and how much the debts were and how much all the heirs inherited. Like, that all becomes public record. And for some clients, having that privacy is really important to them. And for some clients, it's not so much, and so it's really, for that perspective, it's really a matter of personal preference. Whether you do a will or a revocable living trust, we're going to reach the same end result. Whatever you want the distribution to be, we can do that with either option. It's just a matter of how are we going to get there? What vehicle are we going to use to get to that end result? Are we going to go with the will through probate, or are we going to go the revocable living trust, which avoids probate? And so privacy can be a big one for some of my clients. And then also some clients just don't want to have a court or a judge involved in their final affairs. They don't want that. They don't want their loved ones that they've named in their estate plan to have to deal with that added legal process of going through probate. Now, probate in Washington state is pretty streamlined, and in different states it's a different process, and the cost can be quite significant in different states. I know we're over on the West Coast here with Seattle, so I know California is a big one where clients want to avoid probate at all costs because of the cost involved in probate and the time and factors like that. I'm not licensed in California, so I've never actually done a probate in California, but I've heard that repeatedly from people who are either from California or just have experience with probates in California that you want to go with a trust if you're in California. But I don't know, that's outside of my scope. I don't practice in California, but here in Washington, probate's pretty streamlined. But for some clients, they just don't want that added step in the process for their loved ones when it comes time to administer their estate, and so they prefer a trust just to keep it out of probate, to keep a court out of it, and then again for the privacy factor and things like that. So those are kind of some of the reasons why a person would want a trust. And if somebody has real estate in multiple states, all the more reason why you may want to consider a trust for your estate plan. So if you need to get your estate plan done, or maybe it's time for some updates, it's been a while since you looked at your will or looked at your trust, maybe some things have changed, maybe there have been some life events of some marriages or births or deaths, and we really need to kind of reevaluate your estate plan, I'd be happy to help you. The number here is 206-408-8158, or you can visit us below at dallawfirm.com, but I'll have all that below for you. So I hope that was helpful, and have a good day. Hi, I'm Darcel Lobo, and I own DAL Law Firm, and today we're answering a question about revocable living trusts, and if your home is in your revocable living trust, can you sell it? The title on your home has been updated when you put it into your trust, which you did for estate planning purposes. And so sometimes when clients want to sell that home, they want to make sure, well, can I sell it? It's not in my name, it's in my trust name. And the short answer is yes, you can. I mean, that's the 10-second answer to that question is yes, you can sell your home if it is in your revocable living trust. But let's talk about a little bit more details about that. So with a revocable living trust, many times people create that trust because, if they own more than one piece of real estate, they have real estate outside of Washington State, they want to avoid probate, they want more privacy, they don't want their family or loved ones to have to go through a court process, they don't want the added expense of probate. So there's a wide number of reasons why you may have a revocable living trust. And when you create that trust, in order for it to work, it has to own the assets. And so for any real estate that you own, it should be in your trust, unless you have it in an LLC or corporation and is otherwise handled. But you shouldn't have any real estate in your personal name once you've created a trust. And so with it being in your trust, if it's your trust during your lifetime, you have full and complete authority over your trust. And so yes, you can acquire future assets, you can sell assets that are in the trust, you can do all of those things. And so if you're your own trustee, then you'll have that authority. If you are a successor trustee stepping into that role because the original trustor has passed away, you should also have that authority. So a review of the trust itself to confirm would always be ideal. But again, if it is your own trust, then yes, you would have that authority for a revocable living trust. And so when you go to list the home for sale, if you're using a real estate agent, they will send the property information to a title and escrow company, and they will pull what is called a preliminary title report. And they will review the title report and see that your home is as part of your trust and part of your trust assets. So they will ask you for what's commonly referred to as a certification of trust, which specifies what the trust name is, what date was it effective, who has the authority to act, and they want to confirm that you have the authority as the trustee or as a successor trustee to go ahead and sell that real estate on behalf of the trust. And so once they've approved that, have reviewed and approved that, then you proceed on with listing it and selling it just as you normally would. But as the seller, when you're signing listing documents, when you're signing any offers, you will do so in the name of your trust. So if the name is, the John Doe Revocable Living Trust, the seller on that contract to sell the home would not just be John Doe. It would be John Doe Revocable Living Trust. And then John Doe would sign as the trustee of his trust on behalf of himself, essentially. And so that is one difference, is that the seller will be the name of your trust, not your individual name. But otherwise, it all continues on just the same. You will still have escrow and sign closing papers. You'll receive the sale proceeds. And if you are both the trustor and trustee, so this is your trust, you created it, when you sell it, the sale proceeds get reported to you individually under your own social. A revocable living trust does not have its own tax ID number, while the original creator, the trustor, you, are still living. It just uses your social. And so that sale gets reported through your social. So the trust would not have its own tax return at that point in time. It's all just done through your social and then reported according to your taxes. If you have questions about taxes and capital gains, you'll want to talk to your tax person. Generally speaking, the first $250,000 of capital gains is exempt for an individual, $500,000 for a married couple. But again, I'm not a tax attorney. I don't really give a lot of tax advice. So I would defer you to your tax professional, your CPA or tax preparer, to confirm that for you. And those numbers could change over the years, so that's where it is currently, but that could change. If you are a successor trustee, meaning that the person who created the trust has passed away, and now you're stepping into the shoes as successor trustee, then at that point in time, the trust would get its own tax ID number, and that sale of the home would be reported under the trust tax ID number. So not your social, not the decedent's social, but under the trust tax ID number. But again, that's only if this is not your trust and you are the successor trustee of someone else's trust and you're administering that trust. And so depending on, again, if it is your trust or if you are the successor trustee, how those sale proceeds get distributed are going to be different. If it is your trust during your lifetime, the sale proceeds just go to you. If you are the successor trustee, the sale proceeds get distributed according to whatever the terms of the trust say. So in either scenario, if you have questions about your trust, about selling a home in a trust, and if it's in Washington State, I'm only licensed in Washington State. As much as I would like to help clients across the country, I'm only licensed in Washington State. So if you have a trust in Washington State and you have questions about selling your home, if you're considering forming a trust and would like to, talk to an attorney to answer some questions for you and decide if that's a good option for you for your estate plan, I'd be happy to speak with you. Our number is 206-408-8158. You can text us, you can call us, you can visit us online at dallawfirm.com, and I'll have all that linked below for you so you have that information. And so again, if you need help with your estate plan or some residential real estate, I'm Darcel Lobo. I own DAL Law Firm, and I'd be happy to help you. Thank you. Hi, I'm Darcel Lobo, and I own DAL Law Firm. I'm an attorney here in Seattle, and today we're going to talk about what happens if you forget to put your real estate into your Revocable Living Trust. Now we're making this video because we previously did another video talking about how to fund your Revocable Living Trust. I will link that one here in case you haven't seen it so you can watch it later. But let's talk about what happens if you forget to put your real estate into your Revocable Living Trust. Now, if we can just back things up a few steps, now why do clients create a Revocable Living Trust? For most of my clients, they do so because it avoids probate. That's usually the biggest reason. There can be some other reasons, but that's the biggest one. And so when we create your Revocable Living Trust for your estate plan at our office, we ensure it is funded. We put your real estate into your trust for you. We do a personal property assignment. We get your assets into your trust. But as your attorney at that time, I can only fund the trust with the assets that you own at that time. So when you leave my office, we're done. Everything is good to go. But going forward, after we've signed everything and everything is done, as you continue to grow your assets, and we're really talking about real estate here, you have to ensure that that real estate gets into that Revocable Living Trust that we created for you. Now, why? Why do you have to do that? Because your Revocable Living Trust can only control what it actually owns. So if your trust does not own the asset, your trust cannot control the asset. And if it doesn't control the asset, then what happens? It goes into probate. A probate will be opened even if you have a Revocable Living Trust because you acquired future real estate and did not get that real estate into your trust. And then you might be thinking, well, wait a minute, I created this revocable living trust because I don't want probate. That's why I did it. And I know, but if you bought real estate after your revocable living trust was formed and it didn't get transferred into your revocable living trust, that house will have to go through probate in order to get transferred into that trust that you created. And I know it's not what you wanted to have happen. And it's not the end of the world to have to go through probate, especially here in Washington State. It's pretty reasonable compared to other states where it's very expensive and timely. As I understand it, California is a place where you don't want your estate to go through probate. But when we go through all the time and the effort, not to mention the cost, to create your revocable living trust to avoid probate, and then probate is needed anyways, that's just a really frustrating thing to know that could happen, right? So, and because this has happened, we've seen it happen many times, unfortunately. Even with your revocable living trust, our office will create what's called a pour over will. You may have heard of this term. What is a pour over will and why do we call it that? Well, we have some crazy names for a lot of legal documents, but it's called a pour over will because it's pouring over the assets you forgot to put into your trust. It's pouring them into your trust for you, but it only does so through this pour over will, and that only happens because the will goes through probate, okay? So what does your pour over will say? It's a pretty simple will. It's pretty short. It says, any asset that, and I'm paraphrasing here, right? But it essentially says, any asset that I own when I pass that needs to be probated goes into my revocable living trust, and my successor trustee will administer it according to the terms of my trust. That's what it says. But it has to go through probate because it didn't get into your trust. So I say all of this to say, when creating your estate plan, whether it's a revocable living trust or whether it's a will estate plan, it's not a one and done event. I recommend that we reevaluate your estate plan every maybe 5 or 10 years, or whenever there's a major life event. Now, what's a major life event? It could be a birth, it could be a death, it could be a marriage, it could be a divorce. There's, a number of major life events that would warrant reevaluating your will. Those are the 4 biggies that we usually deal with. It's not uncommon for me to have a client come to me maybe 30 or 40 years after their will was drafted. And there's a lot of changes that are needed at that point that we're able to do for them, but certainly 30 or 40 years shouldn't go by before we're reevaluating your estate plan. So, if you have a revocable living trust, if you want to create a revocable living trust, we are happy to help you. But we have to ensure that your future acquired assets get into your revocable living trust. And it's very simple to do with real estate. If you buy another home, if you buy another home, investment property or whatnot, we will do what's called a quitclaim deed, Q-U-I-T, quitclaim deed, that after you've bought that home, if you bought it in your personal name, we will quitclaim it into your revocable living trust, so your trust controls it. We prepare that deed, we sign it with you, we record it with the county for you to make sure that that is done. So your trust will control that piece of real estate. And remember that during your lifetime, even though your assets are in your revocable living trust, you have full and complete control and authority over those assets. You're not giving those assets away. You can sell them, you can refinance, you can lease out the home, whatever you want to do. But you're doing so as the trustee of your revocable living trust. That way, upon your passing, the person you've named as your successor trustee can then administer that asset according to the terms of your trust and make sure it gets to the heirs and beneficiaries that you have named in your trust. So if you need help with a Revocable Living Trust, and if you're in the Seattle area, I'm only about 20 minutes south of Seattle. I'm in Normandy Park, and I'd be happy to help you. Please feel free to visit our website, dallawfirm.com, or give us a text or call at 206-408-8158. Thank you, and have a great day. Hi, I'm Darcel Lubbo, and I own DAL Law Firm in Normandy Park. And today the question that we're going to answer is, does a Revocable Living Trust have its own tax ID number? There can be a lot of confusion with this sometimes, and clients thinking that the trust needs its own tax ID number. So the answer is, it depends, right? That's such a lawyer answer. But the short answer is no. During your lifetime, the Revocable Living Trust will not have its own tax ID number. You just use your social, right? So everything flows through you. You still have complete control over the trust, the assets in the trust. So it just goes through your social during your lifetime. It will not file its own tax return. It does not have its own tax ID number. So then why did I say it depends? Well, because upon your passing, then it will get its own tax ID number. So during your lifetime, when you created your Revocable Living Trust, it uses your social. Once you've passed, the trust becomes its own entity, and whoever you have named as your successor trustee will apply for a tax ID number or an EIN number from the IRS for the Revocable Living Trust, which upon your passing becomes irrevocable. The trust cannot be changed upon your passing, and your successor trustee is just following the direction that you have outlined in your trust as far as what the distributions will be. So upon your passing, it will get its own tax ID number. But during your lifetime, while you are in control and managing, your own affairs and handling your own assets, it's just through your social. So like if you sell a home that's in your trust, the reported sale, like from escrow, will just be included. Those proceeds will be included in, in your personal income. Now that's a separate question about, capital gains and tax on that, but that's something for another video, for another time. The short answer and what the crux of today's question is does the Revocable Living Trust have its own tax ID number? So again, in short, no, it'll use your social upon your passing, then it will get its own tax ID number. Now there's other types of trust. Revocable Living Trust is the main type of trust that my office uses to help clients who want to, avoid probate, have more privacy. For various reasons, clients will elect to have a trust, but there's other types of trust as well, like, irrevocable trust. And so different types of trusts may have their own tax ID number. So today the question is only about Revocable Living Trust, and that is the answer to that question is that no, it'll just use your social until you pass, then it'll get its own. So if you need help with your Revocable Living Trust, if you want to create a Revocable Living Trust, if you're not sure if you want a Revocable Living Trust, but you know that you want to get an estate plan in place, or maybe you have an estate plan from 10 years ago, 20 years ago, maybe longer, maybe there have been changes, in your life, that you realize that it's time to update your estate plan, feel free to give us a text or a call. I'm happy to help. Our number is 206-408-8158, or you can visit us online at dallawfirm.com. And I'll have all that below for you to reach out to our office. And also just a quick note, I am located in Washington State. I'm only licensed to help people in Washington State. So if you are outside of Washington State, as much as I would love to help you, I'm not licensed to do so. So if you're in a different state, you might want to contact your state bar association or a county bar association where you live to get a referral to an estate planning attorney in your area. Again, I'm only licensed in Washington State. So if you're in Washington, feel free to reach out. I would love to help you. All right, thank you and have a good day. Hi, I'm Darcel Lubbo and I own DAL Law Firm, and today we're going to talk about how to fund your Revocable Living Trust. But let's first start and talk about what is a Revocable Living Trust. It is an estate planning document where you are providing for the disposition of your assets within a revocable living trust as opposed to a will. With the Revocable Living Trust, one of the main perks behind it is that it is not required to go through probate. And so that's one reason why clients will want to use a Revocable Living Trust, is that it avoids probate for your estate. However, in order for a Revocable Living Trust to work, the trust has to actually own the assets. So when we create a Revocable Living Trust estate plan for our clients, we are also funding that trust for you initially based on the assets that you own at the time. So what does that look like? How do you fund a Revocable Living Trust? What do I even mean when I say that? For your real estate, if you own any real estate and it's in your name, when I do your Revocable Living Trust, one of the documents we're also going to review and sign is a quitclaim deed that transfers your real estate out of your personal name and puts it into your Revocable Living Trust name. Now, during your lifetime, you are one and the same as your Revocable Living Trust. So you have full authority over that property still. You can live there, you can rent it out, you can refinance it, you can sell it, whatever you wanted to do, just the same as you would as if it was in your personal name. But putting it into your trust name allows your trust to control it, and you control it as a trustee of your own trust. But upon your passing, you have named someone as your successor trustee to make distributions according to the terms of your trust, and your property is included inside that trust. The trust only works if it owns your assets. So if you have your primary residence and you have some investment properties or a rental property or a second home or any other real estate, we need to make sure that we get all that transferred into your trust. So I'm going to ask you about that during your initial consultation about what real estate you own. For any real estate you own in Washington State, which is where I am licensed to practice law, we will handle that for you. If you own any real estate outside of Washington State, I will help connect you with an attorney outside of this state, so whatever state the property is located in, we will get that transferred into your trust as well, using an attorney who's licensed in that state. So that's how you fund your trust with real estate. But you have other assets beyond just your real estate. So we also are looking at your financial accounts. So checking and savings and investments and any other kind of financial asset you have, we need to make sure that we review your beneficiary designations. So for a married couple, they'll usually have the spouse listed first. But if we create a trust for you, many times you may want that trust to be the alternate or contingent beneficiary to your spouse, meaning that those funds will come into your trust as well and be distributed according to the terms of your trust. And if you have multiple beneficiaries, that might be a more effective way to name the beneficiaries, is just to name your trust, and then your trust will control how that's distributed. So that's another way that you're going to fund your trust, is ensure that your trust is named as the beneficiary if you want those accounts to come into your trust and be distributed according to the terms of those trusts. Now, we also have other assets that don't have titles, that don't have beneficiaries, such as your personal property, the personal possessions in your home, and things of that nature. So with your trust document, we're also going to prepare what is called a personal property assignment, which is signed by you that says whichever properties I own, I intend for those to be owned by my trust and distributed according to the terms of my trust. So upon your passing, we're going to provide in your trust that says what goes where. Maybe everything goes to your children equally. Maybe it goes to a charity or friends or other family. We're going to outline the details of your estate and those distributions in your trust. And so all of your assets will be in the trust and be distributed according to the terms of the trust. When you come to our office here at DAL Law Firm, we assist you with all of that. And we make sure that we have funded your trust when we create the trust and we sign those documents with you. But that's only for that point in time. So if you acquire future real estate, if you open new financial accounts in the future going forward, you'll want to ensure that you have your trust named as at least the alternate beneficiary, not your primary beneficiary. If you acquire future real estate, you want to ensure that you're giving us a call to say, hey, I bought this property, so we can get it into your trust for you, because the key behind the Revocable Living Trust is that it has to own the asset that you want it to control. So if you buy future real estate and it's only in your personal name, then it's not in your trust. And if you were to pass without it being transferred into your trust, it probably would need probate for that asset to be moved into your trust through probate. But the key behind the Revocable Living Trust is that we want to avoid probate. But we can only do so, again, if it actually owns the assets. So if you have a trust, but you've acquired future assets and we need to get those into your trust for you, we're happy to do so. Give us a call. If you're looking to get an estate plan done and you're thinking about maybe a Revocable Living Trust or have some more questions about it, give us a call. We're happy to help. I'm happy to schedule a consultation to discuss what your options are and figure out what's best for you. Our office number is 206-408-8158, or you can reach me by email. My email is darcel, D-A-R-C-E-L, @dallawfirm.com. Thank you and have a great day. Hi, I'm Darcel Lobo and I own DAL Law Firm in Normandy Park, and today we're answering a question about estate taxes and inheritance taxes and how to understand them, when would they apply for Washington state matters. I'm an attorney, but I'm only licensed in Washington state. So if you're in Washington and have questions about estate taxes or inheritance taxes, you're in the right place. So let's talk about, and let's just dive right into it. So an inheritance tax is a tax that is assessed on the beneficiary who receives the money. So if you as a parent are leaving an inheritance to your child, an inheritance tax would be a tax charged to that child for receiving that inheritance from you. We do not have an inheritance tax in Washington state. That is not something that you'd have to consider or worry about, at least at the time of this recording, which is, 2024, we do not have an inheritance tax in Washington state. But what we do have is an estate tax. So that is a tax that is assessed upon your estate upon your passing before the inheritance is transferred to your child in that scenario. It doesn't matter. It could be a child, it could be family, friend, whoever you're leaving your inheritance to or your estate to. That's what we're talking about in comparing an inheritance tax and an estate tax. So again, no inheritance tax. We do have an estate tax. When would your estate have to pay that estate tax? Now let me be clear that this is not a tax that your heir or beneficiary is paying from what they receive. This tax comes off the top before anything is distributed to your heirs. So your estate is paying this tax. If the value of your estate, again, we're in 2024 right now, this could change in the future, but as of right now, the threshold is $2.193 million. If the value of your estate is under $2.193 million, there is no estate tax from Washington state. If the value of your estate is over $2.193 million as of the date of your passing, then there probably is going to be a tax charge. Now you're going to want to ensure you're working with an attorney and your CPA to ensure that this is done correctly and calculated correctly, because we're talking about a large amount of money potentially here. So if the value of your estate, and let's just make this easy, let's say the value of your estate is $3 million, that first $2.193 million of value of your estate is exempt. There's no tax on that first $2.193 million. But for the amount over that, and if the value of your estate is $3 million, you're looking at a little over $800,000, which it could be subject to tax. then the threshold for the tax is between about 10 to 20%. There's a table that breaks down what that tax may be in Washington State, and so I will link that tax table in the description below for you in regards to how much that tax may be. So again, the first 2.193 million is exempt. So if you're under that threshold, no estate tax. If you're over, that first 2.193 million is exempt, no tax. Anything over is subject to the estate tax. If you are married, you can potentially double that exemption with proper estate planning to protect, I think it's about 4.386 million. If I'm doing my math correctly and doubling that number correctly, it is 4.386 million in value of an estate that can be exempt from taxes. However, you have to do some planning with your estate plan, with your will, with your trust, to make sure that you are able to double that exemption as a married couple. So that's why it's so important to make sure you're working with an estate planning attorney who can help you with your estate plan, assess if there may be taxes, and help you in doing that planning to minimize or maybe even eliminate any estate tax altogether. If you are in Washington State and would like help with doing your estate plan, whether it's a will, whether it's a trust, if you need to get your power of attorneys in place, if you want help with your estate plan, if you have questions about tax planning and want help with that as well, feel free to reach out, give us a call, give us a text, send an email. We'd be happy to schedule a consultation to meet with you. The number is 206-408-8158. I will have that link down below along with all the ways that you can reach out to contact us. Thank you and have a good day.